Hello, everyone, and welcome back to Kevin's Corner. This is Kevin Horner of Galligan and Manning doing our weekly Facebook Live segment where we get to talk about some estate planning and elder law issues. If those of you who have tuned in before already know the format, but basically I'm going to talk for maybe 5, 6, 7 minutes, and I'll talk about some topic that's relevant to what we do. If you have any questions or anything you want me to address, just put a comment in, and if I can talk about it now, I will, especially if it's all related to this. And if not, I'll talk about it in a future segment. And today, normally I kind of amble my way around, but I have a lot to say today, so I want to try to jump into it. I'm going to talk about something that people don't think about with their estate planning, but is critical, is the titling of the things they own and beneficiary designations. It's the other aspect of estate planning. And this is something that tends to have traps that people don't think about, but they fall into, and it ends up sort of frustrating their estate plan. So what we're really talking about here is, you go to the lawyer to get the will, to get the trust, to set up your estate plan, you get those legal documents, which is great. But how well they work depends upon what you own. If you own things that have joint titles, or if they all have a beneficiary designation, like life insurance or an IRA, those documents, not the legal documents, will say where those assets go when you die. And if they don't fit with the rest of your estate plan, you might either get to the wrong beneficiaries or you might just not get the result that you were looking for. So I figured I would just talk about maybe like 3 things that are common problems, common things to think about, just as a food for thought and something that's worth reviewing in your own estate plan if you haven't. First and foremost is the joint titling of accounts. I think probably everyone here, especially when your parents have gotten to a certain age, if nothing else, has been told by a bank teller, for example, just add your name onto mom and dad's account so that you can write checks if they can't do it themselves. Sometimes that's good advice. It does certainly follow something that generally we're a fan of, which is the account will avoid probate. But depending on what state, and I should say that all of these topics today, I know I have audiences in multiple states, this gets very state specific, so it's got to be tailored to where you are. But sometimes just adding a name to an account means the other person actually owns it, as opposed to the convenience aspect that people are thinking of. So I've actually had an estate, someone I knew very well, who was told to add their name onto an account of the parent. The parent passed away, and the account also had a line of credit against it. So not only did they actually own part of the account, which was great, but they also were liable for the debt that was associated with the account, which is obviously not what they were expecting, certainly not what the bank was going to recommend, but it's the actual result. They added their name on and they owned it. Furthermore, in those kind of situations, if you have a joint account like that, and it's what's called a right of survivorship, it just goes to the survivor if that's the way it is set up, as most bank accounts are. Instead of having the will directed or the trust directed, it just goes to the survivor. So let me give you an example. You have a basic will that says, I leave everything to my 3 kids. And you have a checking account, no spouse, and you put one of those 3 kids on it. And it's a joint tenants with rights of survivorship account. When you die, the will doesn't control that bank account. The surviving kid just owns it. That might be okay. I can pretty much guarantee it's not what you expected it to be, and it's never actually going to go down to those other 3, to the other 2, excuse me. How that'll work, I'll come back to in a minute, but usually that is a problem people don't anticipate. All of those situations, just having access to the money, being able to gain control of it, are avoidable through other circumstances. If you're using a will during incapacity, you'd have to use something like a power of attorney, give the ability of another person to write checks on your account, which is very easy to do. If you're using a living trust, then it's even easier. Then you have the trustee already in place who can automatically start controlling that asset, whether the person is alive or deceased. You avoid probate, you deal with incapacity planning, you cover all of it. It works very well. And I should say too, depending on what states you are, like I'm admitted in Pennsylvania where we have inheritance tax, there's an inheritance tax that charges dollar for dollar based upon who receives your money. And if it's a joint account, the person who pays that, in most cases, depending on the circumstances, is going to be the joint title holder, which is probably, again, not what you expected. So the point is, with the joint accounts, people mean well, but you need to think about it beyond just, I want to get access to the money, I want my daughter on, I want my son on, whatever. You need to look at it as the whole to make sure it gets the right result. So that's one, is just think about joint accounts and if it fits with what you wanted. 2 is one that's very common now, but in a sense, it's a simple thing to think about. It is, a lot of people nowadays have a lot of their value in 2 places: the home they own and then in retirement funds that they have maybe a good pension, they have a good 401k, a good IRA, or that's what they've been squirreling away, and they've been spending most of the liquid money to get through life. Makes perfect sense. All of that money, the IRA, the 401k, the retirement, is probably going to pass by beneficiary designation. And without getting into all the complexities of this right here, a lot of times you have to take that money out during your lifetime. It's your required minimum distribution, and you do it based upon your life expectancy. If you have the beneficiary designation set up right, so that it goes to, say, a trust for a child, when you pass away, instead of just giving it all to the child and then having them take it out at your life expectancy, they have the option of doing what's called a stretch. They take out required minimum distributions based upon their life expectancy. They are younger in this scenario, which means the money grows much, much longer. A lot of the benefit of that is outside of the scope, certainly, of this talk, and it tends to fall into more of finances, but it's something very commonly that people don't even think the first thing about, and it becomes a trap or certainly a benefit that they miss out on. So that would be the second one. Just think about, are you getting the right tax consequences of what you're doing? And then third is sort of general, and it kind of fits into the first two things we talked about, is does your beneficiary designation actually fit with your plan? I already described the very common scenario of you put one child on your bank account and therefore the other two don't actually get any of the money. We see this too, certainly obviously that one, but let's say you have one child who for some reason shouldn't take the money. Disability, a known problem with creditors, pending divorce, things of that nature. There are good reasons not to simply give them a sum of money, which I completely agree with. However, what people sometimes do is they leave it all to someone else in the family, and then you always hear this: they'll do the right thing. First, no one ever knows what that means. And two, even if they do, there are new tax consequences. There are new real consequences to what they can do with the money when they have it in their hand. Then they have their own divorce creditors, their own health situation. They might not do anything with it right away and then get hit by a bus, and then it goes to their family as opposed to who you were going to leave it to. The far easier way to do it is to make sure you set up a plan that fits for all of your kids, including for creditors, divorce, disability, and then having a beneficiary designation or having everything flow into a trust for that person so that the money you want to leave them is protected and you don't have to go through the guesswork and really the risks of just leaving it to another person so that it doesn't get into the right place, into the right beneficiary. So those are pretty much, and you can see from a topic like this, I feel like I said a lot in 7 or 8 minutes. There's a ton of things to discuss in this. I just wanted to hit the three. The first being consider things like joint accounts and its actual effect on your estate plan. The second, the benefits of doing proper beneficiary designations to the right entities so that you get better tax consequences. And third, just simply making sure it fits so that the right beneficiaries are getting all of that money. And I can probably, a good way of saying this is if you have a good estate plan, or I should really say a good estate attorney, they will have reviewed who or to whom those monies are going through beneficiary designations. Titling is important. Getting it to the right place is good. Most, our office included, especially for things like retirement funds, will give suggested language for beneficiary designations to help you get it to the right place. Because it only makes sense. You spent your whole life earning those monies. You just paid to have a new estate plan. You want to make sure all of those other monies outside of the four corners of those documents gets to the right place. So if that's something you haven't done, or if you've been given the advice of just add mom or, add kid to it for convenience or whatever, that might be okay, but it probably is worth taking a look at to make sure that in the end of the day, the whole flow of the estate plan will get to the right beneficiaries in the right way so that it's good for state purposes, it's good for tax purposes, and it's good for both you and your beneficiaries. So I said a lot of things, and I'll just rehash them quickly. Make sure you be careful with things like joint accounts. You make sure you get the benefit out of your accounts through IRA designations and 401k designations. And then lastly, simply, does it fit? Does the beneficiary designation or titling of the asset get it to the right place? So if you have any other questions, by all means, you can send in a comment or you can have a free consultation to talk about it. It's obviously extremely important. I thank you all for tuning in, and I look forward to seeing you next Thursday. By all means, give any comments if there's anything else you want us to address. And thank you all very much.